If you're applying for a marriage-based green card in 2026, there are two changes happening right now that can derail your case even if your marriage is real and you did nothing wrong. Change one is a tougher world for hardship waivers. If your case depends on a waiver, the bar is getting higher and the wait is getting longer. Change two is the return for a much broader public charge rule, what many people call the wealth test. It is not fully in effect yet, but the proposed rule signals where decisions are heading, and it can change what officers focus on when they look at your finances. In this video, I will break down what is happening, who is most at risk, and the 5 steps you should take right now to protect your marriage-based green card application. Stay until the end because there is one public benefit mistake families are making out of fear that can hurt them for no reason. Hi, I'm immigration attorney Julia Sverdloff. Let's get into it. The two changes you need to understand. Let me simplify this. Nothing here means marriage green cards are impossible, but it does mean the process is becoming less forgiving for couples who have vulnerability in their case, especially prior immigration violations like unlawful presence or entry without inspection, certain criminal issues, borderline financial sponsorship, and public benefit confusion. The two biggest shifts are the first one is hardship waivers. They're becoming scrutinized harder with long processing times. And the second is public charge is being expanded in a proposed rule which signals broader financial review. Now let's break those down in plain English. First one, hardship waivers, why they matter and what is changing. If you're married to a U.S. citizen, that does not automatically erase every immigration problem. If you have certain issues in your background, USCIS can find you inadmissible and deny the green card even if the marriage is real. Common triggers include unlawful presence, certain misrepresentation issues, and other grounds depending on the facts. For years, the lifeline for many couples has been a hardship waiver, often on Form 601, or provisional waiver on Form 601A, depending on the situation. The idea is simple. You prove that the denial would cause extreme hardship to a qualifying relative, usually a U.S. citizen or permanent resident, spouse or parent, not just a normal pain from separation. Extreme hardship often means layered hardship, like medical, financial, psychological, or caregiving realities that are documented and specific. What is changing is not that waivers disappeared. What is changing is the feel of the education environment. More cases are getting pushed into request for evidence, and more cases are being expected to include stronger third-party documentation upfront, and the processing times are brutal. Many sources are now citing around the high 20-month range for 601A averages, with USCIS itself warning that 601A processing can be very long based on their processing time metrics. What this means for you. If your green card plan depends on a waiver, time is not your friend. A weak waiver packet does not just risk denial, it risks long delay and then a denial. Example, someone entered lawfully, overstayed, and now needs a waiver strategy tied to a qualifying relative's extreme hardship. A couple years ago, a thinner packet might have squeaked through. Now officers often want the full story, backed by records, timeline, expert letters when appropriate, and very clear declarations. What is the practical takeaway? If you think you need a waiver, treat it like the main case, not as an add-on. And the second, the wealth test. Public charge is expanding again. Now let's talk about the second change, public charge. Public charge is the government's way of evaluating whether an applicant is likely to become primarily dependent on the government in the future. Under the current rule that has been in place since the Biden era 2022 regulation, the focus is much narrower, generally tied to certain cash assistance and long-term institutionalization at the government expense. Here's the important 2026 update. On November 19, 2025, DHS published a proposed public charge rule that would rescind key parts of the 2022 framework and give officers broader discretion, including removing the prior definition that limited what counted as receipt of public benefits. The public comment period was open through January 20, 2026. This matters because even before a final rule takes effect, the discretion of travel influences how people prepare and what officers may emphasize, especially on financial sponsorship and total household stability. What this means in plain English. If this rule is finalized in a broad form, officers could have more room to weigh factors like income, assets, debt, health, and overall financial profile, not just whether you meet the minimum affidavit support requirements. So if you are sponsoring your spouse and your financial picture is tight, you should not assume meeting the minimum on paper is the end of the story. Who is most at risk in 2026? These changes hit some couples much harder than others. You should pay extra attention if you have an unlawful presence or past immigration violation, and you were counting on a waiver, you have a complicated history that requires heavy discretion, your sponsor's income is near the poverty guidelines minimum, your household has high debt or unstable income, you're confused about public charge benefits and whether it's safe under current rules. This is where people get blindsided. They think our marriage is real, so we are safe. Real marriage is necessary, but it is not always sufficient. Public benefits trap, do not panic and hurt yourself. This is the part I promised at the beginning. When headlines hit, families panic. People start dropping medical care, they stop using nutrition programs for kids, they make feared decisions. Here's the truth. As of now, in 2022, the 2022 public charge framework is still the governing rule for USCIS adjudications, and many benefits people are scared of are generally not counted under the current rule in the way rumors suggest. Also, benefits used by U.S. citizen children are treated differently than benefits used by the applicant, and lots of programs do not fall under the narrow bucket the current rule focuses on. So the move is not to panic. The move is to get accurate guidance for your specific case. So do not accidentally harm your family or case based on internet rumors. And here are the 5 things that protect most couples in 2026. First, build a strong financial file that you think you need. Get your sponsor's tax transcripts, current pay stubs, employment letter, bank statements, and a clear list of debts and monthly obligations. Do not wait for an RFE to organize your life. The second is consider a joint sponsor early if income is borderline. A joint sponsor can be a lifesaver, but it also adds scrutiny and paperwork. Choose someone stable and well above the minimum, not someone barely passing. If you need a waiver, move now and build it like a case file. Waiver timelines are long, and the standard is being applied strictly. Build a complete hardship story with real documentation, not just statements. Medical records, financial records, therapy records when relevant, caregiving proof, expert opinions when needed, and do it before you're forced to do it on a deadline. Fourth, do not drop benefits out of fear alone. Do not make health and food decisions based on headlines. The rule change is proposed, not automatically in effect, and your situation may be safe under the current standards. Fifth, file smart and fast if you're ready. The policies can shift. If your case is ready to file cleanly, there is an advantage to being earlier rather than later. Not rushed, ready. If you're already filed, if your marriage green card case is pending, do not panic, but do prepare. If USCIS issues an RFE, you may be asked for stronger financial evidence or deeper documentation tied to the direction of policy. Have updated pay stubs ready, have bank statements ready, have your relationships evidence updated and organized, and if you get an RFE or a denial, act fast. Deadlines are real, and strategy matters. So what to do next? Today you learned the 2 biggest ways 2026 is changing marriage green cards. Hardship waivers are harder, slower, and more evidence-hungry. Public charges moving towards broader discretion in a proposed rule, which makes finances and stability more important than most couples expect. If you want help building a strong marriage green card strategy for your specific situation, Click the first link in the description to connect with our team. And if you're worried about a visa overstay, watch my next video on what happens when you overstay in the US, because one wrong move there can trigger bars that follow you for years. If this helps you understand your case a little better, make sure you subscribe. I break down real immigration issues, real strategy, and what actually works, so you're not guessing with something this important. Like this video, subscribe to the channel, and I'll see you in the next one.